Good evening, everybody. I'm Chaz Calenda, and this is another episode of Chaz Calenda, Attorney at Law. It's Wednesday night, and as always, we'll be putting the law above politics, as usual. This series has been focusing on several issues of law affecting us here in Rhode Island and nationwide. But tonight we're going to take a look at my vision as a candidate to be the Attorney General in 2022 of the state of Rhode Island and how I plan to take the politics out of the office of the Attorney General. Joining me tonight to discuss my vision for the Attorney General's office and help me get through the topics is Pat Ford of the Coalition Radio Network. And I'd like to start with our a little clip that we have of our current Attorney General, Peter Nerona, when he was asked about the latest bill signing of some of the gun laws that were passed by the General Assembly this past week. If we can roll up that clip, I'd like to see what the Attorney General had to say.
Attorney General,
Yep.
11-47 of the Rhode Island General Code already contains a number of provisions to fight straw gun purchasing, including regulations that make it a crime to fill out or falsify information on a Rhode Island gun license form, if you will. When you add that to the combination that we're not aware of a single recorded case of concealed carry weapon holders, permit holders.
Who's we, Pat?
The research we've done at the Coalition Radio.
Oh, okay.
So, I mean, that's we.
Okay, yeah. What's your question? What does this legislation add?
Is it really anything more than just?
Yeah, it is. It is
puffery and fundraising. I mean, that's what it appears to many people.
Yeah. So I don't know why you bring a fundraiser. It's nothing to do with it. What it does have to do with is strengthening the penalties for people who buy guns for people who shouldn't have them, and that's what we accomplished today. Thanks for your time.
And yet it won't.
Wow.
Wow is a good reaction to that.
Where is the love?
You weren't getting very much, Pat. I can tell that.
Well, and here's my frustration as someone who feels compelled to report on questions that, for whatever reason, are not asked. I don't want to beat that to death tonight. That's really not our focus. But how come no one asked the obvious? Why we continue to pass laws, and it's after long before this show started. It strikes many in the 2A community, who, by the way, have an incredible record of being in compliance with the law, virtually spotless. I will argue throughout this, and this is as an aside, that quite frankly the record of concealed carry holders, people who have a permit, their criminal record is far cleaner than many of the people who enforce the laws of the concealed carry permit. And so one has to ask the question, why? And given this spider-like network of orgs, as we call them, not orcs, but orgs, of organizations that exist around Rhode Island, many of whom covering the same legal geography, the same legislative geography, one has to ask if it's for fundraising. I can't think of any other compelling reason, because all of these organizations overlap. They all raise money, and they all donate to the same cast of characters. And so, So I guess the focus that we're going to have tonight is to talk about the role of the Attorney General. And we've touched on this obliquely a few times during the now, 12-episode run of this show, and as we launch into our 12th episode, I should say. And I think folks need to understand where an Attorney General's responsibilities lie, what his or her job is, and where is that line in the sand that they should never cross. Now, in our system of government, we've got essentially 5 executive officers here in the state of Rhode Island. We've got the governor, the lieutenant governor, the secretary of state, the attorney general, and the general treasurer. In my humble opinion, and obviously we're going to kind of turn over the mic back over to you in a moment or so, but in my humble opinion, the Secretary of State's office should be depoliticized. The Attorney General's office should be depoliticized. And of course, the General Treasurer's office must be depoliticized. And yet, particularly in the case of the Attorney General, and in particularly in the case of the General Treasurer, we've got these folks showing up, overtly steering legislation, overtly fundraising as a function of this legislation, and I find it despicable. And so let's focus, since you're, full disclosure, you are a candidate to be the Attorney General of the state of Rhode Island. Let's focus on that and talk about what the role is. And I guess we'll start off with the simplest, the most fundamental, and the most basic question of all. A statement and a question, if you will. The Attorney General of the state of Rhode Island, it is my understanding, is largely the people's lawyer and should be advocating on behalf of the citizens of the state of Rhode Island, not so much weaponizing laws and weaponizing politically induced policy against the citizens of the state of Rhode Island. But clear that up for me. Am I right? Am I wrong? How do you see his role?
You're mostly right, Pat. The Attorney General in Rhode Island is actually a fairly unique position. Every state pretty much has an Attorney General, but the Attorney General of Rhode Island has a role that I think only is shared by two other states. That I believe it's Alaska and Delaware, where they're the chief law enforcement officer and handle the everyday prosecutorial responsibilities that go along with that job. Most states have a district attorney or a state's attorney that handles that. Rhode Island, the Attorney General is the prosecutor for the state for pretty much all criminal charges that come through the state. And I think the role of the Attorney General, it couldn't have been phrased better. I think I talked about it a couple of weeks ago with Attorney Mark Rutherford, who appeared on my show. It was cited in the case of the Pennsylvania Supreme Court when they talked about Bill Cosby. Well, the Attorney General would fall under this. The Rhode Island Attorney General would fall under this as, quote, an administrator of justice. The prosecutor is more than just a mere participant in our criminal justice system. They have three distinct and equally critical roles. And I think they laid this out very, very well. They are officers of the court, advocates for victims of crime, and administrators of justice. And that right there is the biggest role that I think is incompatible with what's going on here in Rhode Island in the current administration of the Attorney General's office, is that Peter Nerona is not acting as an administrator of justice. He's acting as a partisan politician. Now you're going to say, there are people in Rhode Island and, do talk radio, podcast, TV, who will say, well, of course he's a politician. It's a political office. That may be true, but it's simply because it's a function of you're running for office, you're running as a whatever it is, there's going to be some politics involved in there. But really, the Attorney General's office should not be making their decisions, particularly when it's enforcing the law, when it's enforcing criminal and civil law, in this case, in the state of Rhode Island. Partisan politics really have no role in the administration of justice. And when you see Peter Nerona standing at a bill signing ceremony, which we've all heard him trumpet these bills that were just recently passed, the gun legislation, the one that banned guns on school grounds and changed the straw purchase, we'll call it, rules here in Rhode Island. I'll get to that later, but he's there trumpeting these bills as if he's a legislator or as if he's the governor, which are strictly partisan roles. They're the ones who make the policy. The Attorney General is there to enforce the law. And he's cheerleading like he just won the Super Bowl. And I question whether that's an appropriate thing for a chief law enforcement officer to be doing, and to be standing there with partisan politicians, acting as one himself, cheering a bill that was essentially passed along partisan lines. And that's where I really got the problem, Pat. And that's where, when I decided I was going to be a candidate for Attorney General, that's what pushed me over the edge to do this, because I've seen from the inside for 12 years, I saw the politics that go on in that office. I've seen it get worse after Peter Nerona took over that office. Just from my interaction, as you know, I do criminal law. I deal with that office on almost a daily basis, and I've seen the partisan politics and decision making that goes on, not only behind the scenes but in front of our faces. And it's got to change, because the people of Rhode Island deserve an attorney general who will fight for them, who will fight for them to protect them. Sometimes that means having to prosecute people, but will fight for them as administrators of justice. And we just simply don't have that right now.
In how many other states, from your experience and your research, are attorney generals intimately involved in the presentation, the preparation, the production, the submission, and then whipping support for legislation?
Well, I've seen it more often in the last few years as everything's become hyper politicized across the nation. But really, the role of the attorney general does not involve any of those things that you mentioned. That's really typically the role of the parties, the partisan parties that are involved in backing their legislators, the legislators themselves, the governor of a particular state. These are the people who are creating the policy. It's very, it was rare up until, I mean, I don't have an exact date, but I would say several years ago, to see such partisan politics infecting the chief law enforcement office of the state, not only of Rhode Island, but of many states. It's come out on a national level. You see coalitions. They call them coalitions now. The coalitions of the Democratic attorney generals, the coalition of the Republican attorney generals. They're all filing suit against the federal government for whatever reason here or there, and they're all joining forces for partisan reasons. It's not because they're out there to protect the people. It's out there to push a partisan narrative, whatever that may be, on whatever side that may be, and for whatever issue that may be. And it's really caused, I think, a lack of trust and a lack of faith in the ability of our chief law enforcement officers to be administrators of justice and fulfill that special role of the prosecutor that the rules of professional ethics for lawyers govern, and case law and state law usually governs when it comes down to what the role of the prosecutor, the ethical role of the prosecutor, should be.
This type of immersion into, some would call it political grandstanding, other would call it being part of a political machine. What impact does this have on individuals' confidence that they'll be fairly treated in a court of law and they'll be looked at in a manner that is blind to their political affiliations?
Well, I can speak for Rhode Island. I can tell you that is a major concern right now. Doing a lot of criminal defense work, you certainly see a different approach taken towards people based upon either a political issue that may be involved with that case, perhaps that person's politics or that person's outspokenness about politics in the state of Rhode Island. And I can tell you that we've already seen examples of it, of the attorney general trying to, I think I'll generously call it, trying to stretch the law to fit their prosecutions into that law. I think we saw it with the Jeffrey Britt matter. I think we're seeing it with some of these so-called hate crime sentencing enhancement cases that Attorney General Nerona has brought and has been unsuccessful with thus far. This is not being done in the name of protecting people, protecting citizens of the state of Rhode Island. This is being done to advance his partisan politics, which, I think anybody watching him who's got a fair mind can figure out what those are.
Once the barriers, if you will, the walls, the glass ceiling, whichever cliche you want to employ, the genie in the bottle, that's one of my favorites. How do you walk that back? Is it possible to walk that back? And I'm just talking right now about the loss of confidence. I've joked with you with my sort of gallows humor on more than one occasion, that one of the catchphrases here is that in the halls of justice, justice is usually found in the halls. And so if you lose, right, that confidence in your ability to go to quote unquote blind justice in this case, let's just say you're a Republican, let's say you're an acolyte of Donald Trump, let's just say that your political differences may be religiously based, and you see decisions being made on polling, decisions being made by outside influence from PACs. How corrosive is that?
It's completely corrosive, Pat. And although I didn't work directly under Peter Nerona as when he became the Rhode Island Attorney General, I saw it happening in the Attorney General's office while I was there. I don't think it was at the level that it's at now, but it certainly was there, that the discussion was being had inside the Attorney General's office before the charging decision was made, is how is this going to look when the press reports upon it? How is this going to look when it comes up for time for re-election? Because the Attorney General is able to serve 2 terms, 2 4-year terms. So every 4 year, after the third and fourth year, when it comes up to election time, they have a record now they have to run on. And unfortunately, you're running in a political environment where they have to make it look good for themselves. And it's terribly corrosive when you have to sit there and look, should we charge this person with a crime because let's just say the Providence Journal is going to ask us, what's our thought decision making process? Is this good? Is this a good decision? How do you justify this? We're going to have to answer this. We're going to have to answer these questions when we don't want to have to answer those questions. And I can tell you those were always considerations. And it was something that did not, it was something that I was very vocal about when I was a line prosecutor in the Attorney General's office, something that didn't earn me a lot of friends actually while I was a employee of the Attorney General's office, because I never thought that should play a role. There was, I'm not going to name the former official, but there was a top-ranking former official in the Rhode Island state government who had a family member was looked at being prosecuted by the former Attorney General's office, Peter Kilmartin's office, and I was assigned to that case. And for the sake of transparency purposes, I suggested that we convene a grand jury to look at these matters so everything could be fleshed out to make sure we weren't out making decisions based on politics. We have an independent body making that decision. And that was denied because they did not want to dig too deeply into this politician's background and what was going on in that particular instance. So, there really needs to be a reckoning of getting the politics out of this decision-making process, leaving the how is this going to look to the press out of the decision-making process. And, one of the ways that I want to do that is to perhaps seek some sort of job protection for the line prosecutors who are in that office, because they all serve at the pleasure of the Attorney General. So that basically means they have no job protection. If the Attorney General doesn't like a decision you made yesterday, he can walk in and fire you today without a reason. And that's what they're facing. They've always faced that. They face that now, and it's now more than ever, because I deal with it on a daily basis, that they are not being given any discretion whatsoever to make their own decisions. And if they make the wrong decision, they all fear for their jobs. And that's been said on the record to judges, to defense attorneys on more than one occasion in open court, that they have to go seek approval from their boss, which is usually the chief of the criminal division. And I'm assuming that Attorney General Nerona has something to say about that as well. And that is just the wrong way to be doing business in the Attorney General's office, whose sole purpose is to enforce the law in a fair and impartial manner.
Let's talk about campaign contributions for a second. Is it appropriate for someone who was and let's look at Mr. Nerona before he was our state attorney general, what role did he occupy up until and when?
He had been the United States Attorney for the District of Rhode Island. He was appointed by President Obama. I believe it was in 2009. He held that role until, I believe, 2017, when President Trump took office. And as is customary on the federal level, when a president of a different party takes office, he generally asks for the resignation of all the U.S. attorneys in the country. Peter Noronha was one of them. And that's what happens. He was relieved of his duties, I believe it was around March 2017. And shortly thereafter, he announced his candidacy to become the Attorney General of Rhode Island, and for which he had almost no competition. There was no Republican running against him. He ran as a Democrat. He had somebody from the Compassion Party running against him, who was, I believe at that time, under indictment and may still be for fairly serious drug charges, but he essentially had no competition. They cleared the path for him, yet he still took a very partisan role while campaigning, and it's continued well into his term into office.
Right. So here's someone who sees himself on an equal level as Democrat and Attorney General, and who has a fealty to a Democratic organization, which obviously has direct input into how the General Assembly is constituted. And in fact, has even made a couple of campaign contributions to Dawn Oyer, to Joe Biden. That's an aside. But is that appropriate? And does that establish, forget about the contributions for a moment, but just the partnership, if you will, with a political party that's so overt, and a direct working relationship with PACs like Moms Demand Action, does that create, if you will, a climate where individuals working in that office who may not support that legislation can, and I'm talking about the political appointed staff as well as the professional staff, can they feel comfortable in that, with those type of political implications hanging over their head?
Well, I can tell you, Pat, from personal experience, no. There's a lot of people that, that probably still work there, and certainly did when I was there, that did not feel comfortable with that situation, because it wasn't a whole lot different under Attorney General Kilmartin, because he had been the majority whip in the House for many years. And, obviously Rhode Island is dominated by Democrat politics, and that is the same as it is today under Attorney General Noronha. And there is obviously a lot of coordination between the political party and the Attorney General's office, and these groups that align themselves with the Democrat organization. I would be complaining the same way if it was a Republican dominated state with a Republican Attorney General and Republican dominated PACs. There really should be no fealty or any sort of loyalty to any political party when you hold the position of the chief law enforcement officer and the administrator of justice in the state, that would influence your policymaking. And I can tell you that there are employees in that office that are afraid to death. They are afraid for their jobs if they speak out against a policy that the Attorney General has come out and maybe publicly advocated for or sought. And one of the things that really gets the prosecutors right now upset, when a defense attorney brings it up in court, was, up until recently, before I believe it passed, maybe you can correct me if I'm wrong, but Peter Noronha had been advocating for the decriminalization, or the defelonization, I should say, of certain types of possession of drugs. And yet, up until recently, those possession charges were felony charges. So a defense attorney would go in and say, we have the Attorney General judge on TV, on his on social media, saying these charges shouldn't even be felonies, yet here we are with their prosecutors coming in and arguing that my client should go to jail because they have felony charges against them. And the prosecutors would be put in an unenviable task of having to defend their boss's political position and then try to defend what the law was. And I can tell you that nobody in that office is speaking out against anything Peter Nerona says publicly, because they will lose their job before you can snap your fingers.
And you've seen some of this yourself, haven't you?
I have personally witnessed this because I have been in those conversations. I have been in those judges' chambers where these things get said. I have been there talking to the prosecutors, trying to resolve cases for my clients where they say, that sounds like a reasonable resolution, but I have to get permission from the office in Providence. And when they say the office in Providence, they mean the executive office, which is the Attorney General, the Deputy Attorney General, and in cases of criminal matters, the Chief of the Criminal Division. And these are things that should not happen, because you have a staff full of lawyers who all went to school to be able to use their discretion in a way that ostensibly got them the position to be a prosecutor, to be able to they've proved to somebody that they have the maturity and they have the discretion necessary to be a prosecutor and be an administrator of justice. Yet they are being forced to go to seek approval from their political boss to resolve run-of-the-mill cases. And I'm not talking about first-degree murder cases. I'm not talking about first-degree sexual assault cases or child molestation cases. I'm talking about the regular run-of-the-mill cases that many prosecutors in that office just simply don't have the authority to decide without getting permission from the higher-ups in that office. And I can tell you one thing, that if I am fortunate enough to be elected Attorney General in 2022, that is not going to be the case, because the people who will be working for me will have already proven that they have the maturity and ability to make these decisions on their own in a fair and impartial manner.
What about campaign contributions? Let's talk about that for a second. Clearly, this is going to be an expensive campaign. I couldn't tell you the total number spent, obviously, in the last campaign, but the amount of money that's run through these is astonishing now for jobs that obviously don't pay that well. So one has to believe that, in fact, it's the prestige of the job, the resumes, the connections, the ability, and we've seen so many times with state house leaders, the ability to augment one's personal practice of law, all of that. But what type of organizations donate to an attorney general candidate, from your experience?
Well, looking at Attorney General Nerona's campaign filings, certainly looks like all sorts of organizations, all sorts of political organizations. A lot of his donations come from Act Blue, which is the Democratic fundraising arm, that social media fundraising arm, and that come from all across the country, probably from people who are giving to candidates in other states that are also giving to other Democrat candidates like Peter Nerona. So these campaign fundraising, it's an unfortunate part of the process here, because it is an elected position, and unfortunately, it's an evil that is going to be part of this process. Everybody has the right to fundraise. There's nothing inherently wrong with fundraising. I don't think anybody who fundraises or donates to the Attorney General's race should expect that they should be treated any differently if a matter that involves them comes before the Attorney General's office. But I feel like that confidence is not there when you have someone who's so closely aligned with the state Democratic Party, and not only the state Democratic Party, like I mentioned before. Peter Nerona was appointed by the President of the United States in 2009 to be the U.S. Attorney for the District of Rhode Island, Democratic President, the National Democratic Party. He has a brand that is quite quintessentially very far left-leaning, and it's hard to have confidence that the decisions he's making are devoid of politics.
Right. Because here's the potential, and we're not going to name any one individual with this pattern of behavior, except to understand that it's legal and exists. If someone wants to contribute to a candidate, ostensibly there's a $1,000 limitation, isn't it, for an individual?
Yes.
However, that individual can donate to the candidate, Then they can donate to an endless series of PACs associated with the Second Amendment, associated with the, if you will, with economics, associated with the environment. And then those political action committees can, in turn, then donate to that candidate again. So, and this is perfectly legal, by the way, but the notion that there exists a barrier as to how much one individual can influence a candidate is pure fiction. Absolute fiction.
It is fiction because, as you mentioned, those channels exist to anybody who has the resources to donate to those third-party organizations, and some of those, some of those organizations have millions and millions of dollars to donate. And again, like you said, perfectly legal. Everybody has the right to donate to candidates of their choice or not donate to candidates of their choice. I have to fundraise. Peter Nerona's fundraising. It's something that is unfortunate because this is an elected position in Rhode Island. And I wish, if I had my way, I wish it would be a nonpartisan race, as many races are for judges in other states. They're nonpartisan races, and you basically just go out there, put your name out, and say why you would make a good person for that particular role.
Here is possibly, in a life filled with dopey questions asked on the air, possibly one of the dopiest. And that would be if an organization, for example, and again, we focus on 2A. Let's just say there's an organization out there that is heavily focused on, tightening the controls over which one can own guns, use guns, where they can bring guns. With that donation, call me Captain Obvious, what is the expectation?
Results from the person that is the recipient of their donations. And it certainly, there are many groups that fall into both of those categories that you've mentioned. And, if you are donating large sums of money to individuals who are running for office, and your goals of your organization are quite clear, and you donate heavily to a particular individual, I certainly would think that their goal is to see their agenda put into force. And whether that means through the legislature or through the attorney general in this case, if that doesn't get done, how can you go back to them in 4 years or 8 years, whatever it is, and say, oh, give me more money because I didn't, I didn't get it done this time, but next time I promise I'm going to get it done. You're not going to find me making promises to whatever organizations think that I would make a better attorney general than Peter Nerona. You're not going to find me making promises to them because my only promise is going to be, I will enforce the law, whatever that law is, and I will do it without partisan considerations going forward.
Because let's explore for a minute, if we can, a less known aspect of the campaign finance laws. Now, full disclosure, until recently I was chair of the Libertarian Party of Rhode Island. And while we have not met the onerous requirements in the state of Rhode Island, it's one of the most difficult states in the nation to get full party status. As a result, we had to register as a political action committee. Okay, fair enough. While we don't like the laws, we at the Libertarian Party of Rhode Island, as in the current administration, shares this and is unequivocal in their adherence to the laws, just to make that point. And I don't speak for them anymore. But there are significant obstacles to grassroots organizations being able to compete effectively. It is clearly, Rhode Island is an example of, we took over things and now we're going to close the door behind us so no one else can. What do I mean by that? In the state of Rhode Island, if you're a political action committee, you can only accept contributions. And by the way, anyone who's involved in any form of electioneering has to become a political action committee. You can only accept contributions from political action committees, individuals as well, obviously, but political action committees that have established themselves in the state of Rhode Island. And the way you do that, according to the state laws, and by the way, this was done under the auspices of reform. To me, this was one of the great scam jobs in recent legislative history, which is, in Rhode Island, that's saying something, right? So
Wow.
they
Wow.
created, they created the regulation that, amongst other things, that you had to file reports. If you made one contribution, if the National Libertarian Party contributed $100 to us, they would have to A, register in the state and file all the same reports that everybody else does, and B, equally challenging, maintain a bank account with a local, if you will, local connection to the state of Rhode Island. So you are distinctly limited into what banks they can only be national banks, and there had to be a clear connection so that if the state wanted to, quote unquote, subpoena the banks, if they wanted it to be able to, put their hand into the organization, they could. And you have to maintain a separate bank account. Now that makes sense. But so a number of the grassroots political organizations in the state, in order to get ballot access, can only do so by getting a 5% vote of the gubernatorial vote or 5% of the presidential vote. In order to accept money, that organization has to be either domiciled in the state of Rhode Island or at least be qualified to do business in the state of Rhode Island and fill out of the forms. And also, in order to take their money, they have to have a local bank account. So there's only the larger organizations are going to have the resources to do that. I mean, so the state of Rhode Island works overtime on laws created largely by the Democratic Party to create an environment where it's virtually impossible to compete with this at every single level, reinforcing their strangle-like hold, if you will, on politics and control over, well, as we say in the coalition, the do-re-mi, the skidoo, the money. So on top of that, the organization, if you will, that enforces these laws is political in nature in and of itself, and that, of course, is the Attorney General's office. So a Democrat, what are the odds of getting any sort of hand up or any sort of a level playing field if a democratically elected member of the Democratic regime, which is part of the Democratic machine, is elected to be Attorney General to, in a sense, allegedly be the people's lawyer, when in fact he is able to take political contributions and is supported by members of the Democratic Party in order to get that office. And then a legislature, which is obviously political. So there's no interest, there's no interest whatsoever in the Attorney General's office vetting, talking about the constitutionality, talking about the appropriateness of any of the election laws that were established by a General Assembly, clearly intent on maintaining control. Now, do you have a problem with that? I do. How do you feel about that when I lay it out in that manner?
Certainly, I have a problem with it in the sense that, I'm not a career politician. I have never run for an elected office other than the Coventry Fire District Board, which was nonpartisan. I couldn't raise any money for that, which you don't need to. But, certainly when you don't have a level playing field, it discourages people who would otherwise be very qualified for the job from running for office. And it keeps those who are in power in power. And
Right.
I think that's exactly what you were getting at. And there's very little interest, it seems, genuine. Let me rephrase that. There's very little genuine interest from the current Attorney General in looking at these election laws and the propriety of them and enforcing them in a fair and neutral manner, because he benefits from them just by virtue of his party affiliation and his fealty to the party. And again, I don't want to be here to trash the Democratic Party. That's not my role. That's not my job. That's not what I'm looking to do as the Attorney General. But that's what it is in Rhode Island. Rhode Island is dominated by Democrat policies, and every major office holder in the state of Rhode Island is a Democrat. So let's just look at that. I mean, the one election so-called fraud case he brought, yes, It was against someone who bundled money for a Democrat. But if you ask me, it was done for political purposes because that Democrat was not Democrat enough for the current Attorney General and the current Democratic, let's call it machine for now, in the party. And it was done. The prosecution was done in a overtly political manner, which the judge who presided over the case very clearly wrote in his decision. And it was, I think it was an embarrassment for the state of Rhode Island and the Attorney General's office, the way that case came out, because you could go look in many different corners of the election law and where other people are involved in, and find, I could probably name a myriad of situations which could be investigated thoroughly and adequately by the Attorney General's office. But we took a case involving $2,000 from a bundler for a single race, which apparently wasn't even a crime according to the court, and made a huge deal about this case, and lost spectacularly in the Superior Court in front of one of the most experienced justices that's sitting in that court right now.
Right. Well, a little known event at the Tokyo Olympics, and you may have missed this, is the worldwide gold medal for virtue signaling. Again, it may have missed your attention. My understanding is that members of the Rhode Island Democratic Party actually won nationals, and the results were automatically included as an entree to that. And their featured event, if you will, think of it like an ice skating show.
Okay.
We have a little interference here. Oh, there you go. We're fine now. So their routine includes, of course, this nationwide campaign where they claim they are interested in voter rights. Now, personally and politically, again, my opinion, and as a result, the opinion of station management, is that I embrace voter rights for all. I have no problems, if you will, establishing wide open voter participation. It's all good. But at the same time, if in a move not unlike Soviet-era Mother Russia, as in Socialist Workers' Paradise, if you work overtime, and this is occurring ironically in states like Texas and New York, if you work as a party overtime to erect barriers to entry for grassroots organizations to compete, how are you any different than those that would prohibit people from voting in itself? Because ultimately, if you can vote, but these organizations like the Democratic Party in Rhode Island have worked overtime to eliminate your choices, what's the point, right? What is the point? And yet I see none of the caterwauling, whining, cavorting. No one is verklempt over these very same people denying access to grassroots. And I'm not just talking about the Libertarian Party or the Green Party. There's the Working Family Party. There's organizations and individuals from across the spectrum. And yet we've got an insular system here in Rhode Island. It's self-fulfilling, self-perpetuating, self-perpetrating, where money is donated to candidates, money is donated to PACs in sort of a gigantic, let's call it like a sprinkler effect. But when it hits the grass, when it hits the ground, the money all comes back down to the handful of sources. So there is no effective campaign finance regulations in this state, other than that which can be used in a market-directed manner under an Attorney General's office that has no interest in competing, if you will, on a fair playing field or allowing that. You've got legislation which is grotesquely single-sided. Are you aware of any public hearings that the Attorney General's office may have held with the gun legislation that was recently signed into law?
Public hearings? No, it's certainly not under the legal definition of public hearings, because public hearings normally would fall under the Open Meetings Act or perhaps the Administrative Procedures Act, and the Attorney General's office is not required to follow those rules.
Right. So you've got public policy and public laws being generated by an organization that exists above any of the regulations or political ramifications of input from stakeholders, as we like to say in the year 2021, and those stakeholders having potentially a markedly different perspective on constitutional rights than the current Attorney General does. How does that work, Chaz?
It shouldn't be working like that. And, maybe I'm just pie in the sky. Maybe I'm just naive, and I'm a candidate here for Attorney General. I just happen to be a pretty decent lawyer running for Attorney General. So please, Pat, bring me back down to reality if I happen to float into the sky. But it shouldn't be working like that. There is to have legislation discussed in the confines, perhaps, of the Attorney General's office, where they're not subject to Open Meetings Act rules, and they're not subject to the Administrative Procedures Act, and they're not subject to the openness that even the legislature, as maybe laughable as that might be, that they have an open legislature there, but at least they hold some sort of public hearings when they're debating bills there. That doesn't happen when the Attorney General gets involved. He may go testify in the legislature if they ask him to come and give his opinion there, but who knows if that's what's being said behind closed doors in his office, because I'm certainly not invited to go inside of his office. I'm a stakeholder. I'm a registered voter here in Rhode Island.
I'm certainly not invited.
Yeah, well, clearly with the reaction he gave you, asking your one simple question, clearly you haven't received that invite as well. But, as far as I know, I'm a registered voter of the state of Rhode Island. I believe you probably are as well.
I am.
And we vote. We're both eligible to vote for Attorney General. So I'd like to know what the Attorney General is saying behind closed doors, as far as what legislation does he support that maybe is not shared by everybody else or certain groups of society. What's being discussed behind closed doors is how these laws, if they get passed, wink, wink, how are they going to be enforced? And if you don't think there's a wink, wink that goes on behind that, then, perhaps I can sell you a bridge in New York.
There you go. Well, I think the issue is pretty clear. There needs to be a thorough readjustment. I'll go chiropractic on you for a second. A realignment, a readjustment of the environment under which the Attorney General operates. It is, and please correct me where I'm wrong, because as always, I have to say it at least once a show, I'm not an expert. I merely try to play one on the radio. And it strikes me that it's inappropriate for an Attorney General's office to be setting policy. My understanding and my philosophy is that the only involvement the Attorney General's office should have, and again, please dive in and correct me if this is inappropriate, would be the constitutionality, if you will, of a potential law and its impact, if you will, on citizens' rights. I would imagine in my world that's where they begin and end.
Well, I would say that is certainly a major consideration and an appropriate consideration for the Attorney General. If the legislature is discussing issues of constitutional magnitude and the Attorney General has concerns with it, I believe the Attorney General should make that opinion known, because ultimately it will fall upon his or her lap to enforce those provisions at some point. And if he or she believes that they are not in the best interest or consistent with our constitutional rights, the Attorney General should speak up. And I also do believe that the Attorney General can offer an opinion, perhaps, on the wisdom or lack of wisdom of certain legislation that may be being debated by the legislature, if it's going to negatively impact the ability of him to do his job. I think Peter Nerona used that to his advantage. I don't think it was done honestly, if you're asking me candidly. I don't think it was done honestly when he told everybody he did not have the tools to prosecute straw gun purchases prior to the passage of this latest law. But that would have been, if that was true, which it wasn't, but if that was true, that he did not actually have the tools to prosecute on a state level, straw purchases of guns, then certainly he could make his thoughts known to the public, the legislature, the governor, that I need those tools. Unfortunately, Mr. Noronha did not or did not seem to fully understand that the laws that were already on the books prior to the passage of this latest law, because he already had the ability and a significant ability to prosecute straw gun purchases. Simply somebody providing any false information on an application to purchase a firearm, whatever false information that may be, was punishable by a felony, in each instance up to 5 years in prison. They've changed the law recently, and I think he's actually made it, by pushing for the language that they did, by specifically including the provision that was added referencing straw purchases. Now you added an element to the crime that didn't exist before. You've added an element saying the person, if they knew or had reason to know that the person they were transferring that gun to was prohibited from having a gun, then you're liable for now up to 10 years in prison. So they raised the penalty as well. But how would everybody know necessarily if the person that they may be transferring a gun to is prohibited under state and federal law from holding that gun, unless obviously you're running a drug ring, a violent crime gang, that obvious situations that would be clear. But say I bought a gun and you and I, Pat, go shooting for a recreational event, and you wanted to borrow my specially made firearm to shoot at the range, and I loaned it to you, perhaps, and I didn't know, maybe in your history, maybe you've had a domestic violence dispute, a domestic disorderly dispute way back 20 years ago. Technically, if you were given probation or more on that case, under federal law, you're disqualified for life from even possessing a firearm. Would I necessarily know that if I didn't know that about you? No. So I believe he's actually made it harder to prosecute these cases going forward by adding that specific knowledge that the person must have when transferring a firearm. So, right. I mean, this is what I'm talking about when the Attorney General gets involved in legislating. It's not his role.
Right. Well, sort of coming to the end of the evening here, if you could tell folks how they can find you, but on the web and where they can reach out to you, but as importantly, perhaps leave folks with a sense of how a Calenda administration would be involved, if you will, with the legislature, if at all, and what type of, and they often talk about, that wall. When you look at, for example, and I say this with a wry smile, when you look at media organizations, the wall that's supposed to exist between sales and reporting and then also editorial, and I say that with a smile, equally believable, right? When you look at banking outfits, the wall that's supposed to exist between retail and investment banking and investment opinions, what does a Calenda, if you will, Attorney General's office look like?
It's going to look a lot different than the ones that we've seen over the last several decades. And I will tell you from the beginning, my opinion of what the law is or what the law should be will not matter. My opinion is the law, what does the law say, and is it going to be enforced impartially and fairly? So again, my personal politics, my personal opinions, people I've supported in the past, whatever it may be, will play no role in what I do and how I run that office. My only job is to be, quote, the administrator of justice and the people's lawyer of the state of Rhode Island. And that means all people. I'm not going to be beholden to any political party. You're not going to see me at any signing events, even if I support the legislation that's going there. You're not going to see me posing for pictures with partisan politicians who are out there for photo ops. I am going to make sure that the politics is taken out of prosecution, because I will not allow that to happen in my office. I've been doing this job as a lawyer for 15 years. I was a prosecutor for 12 of those years. And I saw the things that I saw go on in that office in there would make most people ill if they knew the considerations that were going into some of the decisions that were made there. I want to change that. That's why I left the office. That's why I went into private practice, because I simply couldn't take that anymore. I'm going to hire a group of attorneys that know what they're doing. There's already a great group that most of them who are there. They are going to have the autonomy, if they have shown to me, and they will have shown to me, that they are able and willing to put their personal feelings aside and enforce the law as written and not how they want it to be. They will have the autonomy to make their decisions. And I will make sure that I am not part of any sort of political machine that exists in this state, whether they support me, whether they're against me, or whether they think I'm just some guy off the street that just happened to get lucky and get into the Attorney General's office. That's not going to be who I am. I'm going to be the people's lawyer, and I think it's time that we do shake things up here in Rhode Island and make sure that the status quo is not continued in this particular situation. So anybody who's interested in my campaign can find me on the web. I have a website. It's Chas4AG. That's CHAS, the number 4AG.com, where you can learn all about me. You can donate to my campaign, but like I said, that won't get you any special favors. You can also find me on Facebook, Twitter, Instagram, a multitude of social media platforms. It's Chas Calenda for Attorney General is most of the time is the handle I'm using, or Charles Calenda for Attorney General is the handle I'm using. And here on the Coalition Radio Network, I have a Wednesday night show where I talk about several legal issues. You can hear my perspective on several legal issues that have come up not only in Rhode Island but nationally. Usually it's Wednesday night around 8:15, and this is although this is a different type of episode tonight. Usually we're talking about law, what the law is and how it's been applied. So I encourage people to learn more about me. Reach out to me directly. I work at the law firm of Inman and Torgy, which is in Coventry, Rhode Island. If you need legal services or you're just interested in getting my opinion, you can reach me there, 401-823-9200. And I look forward to interacting with everybody here in Rhode Island to show them that I am serious when I say that I want to put the law above politics.
All right.